We have a quorum. This is the appointed time. Let's invite the administration in. Now, the administration has forwarded a response to us, a 4-page document. Would members please refer to it? Paper number 422, that is. Welcome. Good morning. Representative from the administration. I won't go through the attendance list one by one. So over to you, Mr. Vic Yao. Please walk us through the response to questions raised by members last time. Thank you, Chairman. Good morning, members. Before this meeting, we have forwarded our response to the Secretariat in relation to 2 issues raised by members last time. Now, first, in relation to the new approach in describing the list of offences under which surrender may be granted. Instead of a list of offences, alternative formulation is adopted. The background is that when we negotiated with the contracting parties, and Czech Republic being one of them, they raised that because it's incompatible with domestic laws and practices, they do not agree to using the list approach in the agreement, as it has departed from our previous practices. The countries, including Czech Republic, in relation to the negotiations with these countries, they have stalled, and therefore, within our legislative framework, we have come up with another approach, that is the alternative formulation. After we designed this approach in 2005, we consulted the panel on security, and the panel members then had no objection. And then in our international negotiations, we began to adopt this approach. In particular, on requests from the contracting parties, we could then use the alternative formulation. First of all, the alternative formulation complies completely with the requirements under the Fugitive Offenders Ordinance. And Schedule 1 sets out the list of relevant offences under Hong Kong's law, and these offences are punishable in Hong Kong with imprisonment for more than 12 months or more, and the surrender must also fulfill the requirement of double criminality. That is, in other countries, the offence involved must also be punishable for more than 12 months. And all these requirements are not affected. And in relation to views raised by members last time, when we come to the stage where we exchange the list with the Czech Republic, apart from making an announcement in the Department of Justice website, we will also publicize the list of offences through government notice in Gazette. And in future, when similar situation arises, we will invite our contracting partners to exchange the list beforehand before we submit the agreement together with the orders by way of subsidiary legislation to LegCo, so that they can be considered in one go. As for whether it can be submitted by way of subsidiary legislation for the list of offences to be exchanged between Hong Kong and the Czech Republic, according to the ordinance, there is no power in relation to the enactment of subsidiary legislation, so it is not appropriate. However, we will publicize the list to be exchanged with the Czech Republic. And also, for the model agreement, the discretionary ground to refuse requests, accusation against a person is not made in good faith in the interest of justice as a discretionary refusal ground to surrender request. This is not incorporated in the agreement with the Czech Republic. In fact, in other international agreements on surrender of fugitive offenders, this discretionary refusal ground is rarely used, and a person shall not be surrendered if the surrender request is made for the purpose of prosecution or punishment on account of race, religion, nationality, sex, and or political opinions, etc. And we feel that these safeguards are consistent with other SFO agreements in international community, and it's also in line with the United Nations model text of SFO agreement. So, where the surrender request is made on account of the unfair reasons mentioned, we can refuse those requests. So I'm happy to seek views from members. And we also have 2 orders to be scrutinized. So if Chairman, you agree, we can move on to the scrutiny of the 2 remaining orders. Thank you. Mr. Yip. Now, having heard the administration's response and having read the paper, are you saying that it cannot be submitted by way of subsidiary legislation within the scope of the ordinance? Is that the case? And also, is it the case that the list will be exchanged first before the subsidiary legislation will be submitted to LegCo? I find this acceptable. Well, this is preferable because if the list is exchanged first, at least we know what it is about. And when we scrutinize the subsidiary legislation later, we can veto that part which is not contained in the text. So next time the administration, if the administration adopts this approach, the LegCo would know beforehand the list to be exchanged. And I think we need to resolve this on this occasion. And I understand that next stage of this order will be about the commencement notice. And this in itself is also another piece of subsidiary legislation. If this is not passed, then it cannot take effect. So I won't call this an exception, but we need to consider the commencement notice, and by then the list would have to been exchanged. And perhaps by then, in relation to the commencement notice, some member or myself may call for a subcommittee to be set up, and that can be the last gatekeeping, last gate. And I think that we can still veto the commencement notice by then. I find this acceptable, Mr. Leung Yu-chung. I'm sorry, I'm not quite sure about the procedure. You say that in the future the list can be exchanged first, so that at a time when it is submitted to LegCo, the list will be ready so that we are all aware of the list. But the question is not whether there is a list existing beforehand. The question is, for the contracting party, there is no list. For us, we have a list. So how can we ask the other party to accept our list? I don't know if I understand this procedure correctly. So what will be exchanged, may I ask the administration? That is the question this time. The contracting party doesn't have a list. They don't accept the list approach. They only have a broad concept. For us, it's not just a concept. We do have a list of several dozen offenses. Now, in the future, if another state also adopts a broad concept only, how can we allow the lack of a list for the contracting party whilst we have a list in Hong Kong? So the question is not about the list. You explained to us that a list will be exchanged with them. However, their concept is that they don't adopt a list approach. I don't know if my understanding is correct. Their mold is that they don't have a list. So if next time for another country they similarly don't have a list, then how can we exchange a list? Yes, this question has to be asked. We're going to exchange a list with the Czech Republic if this is passed. So what will this be? So my question for Mr. Yao is this. You put it in a nice way just now. However, yes, understood. It's not about the sequence. It's about the content. So in the future, how can you ensure that our list will be accepted by the other party? Well, let's talk about this order first. Yes, let's ask them, Mr. Yao, what will be exchanged at the next stage. Thank you. Now, let me respond to Mr. Leung's question. It seems there is a concern that the contracting party, that is the Czech Republic, may not have a clear list. Well, the case is they adopt a different approach. We have a list of 46 offences under which a surrender of fugitive request may be granted. And if the offences are punishable by a certain level of penalty, then they can be included. So that's their concept. Unlike us, they don't have a list per se, but still they have a clear scope of list of offences.
Back to the Chairman's question. What happens at the time of the exchange? This is the first time, and we've not officially received the information provided to us by the Czech Republic. In the course of the negotiation, indeed, they suggested that in Czechoslovakia, all criminal offences would warrant a certain threshold of punishment would mean that the fugitives could be surrendered. But I think we have to wait until they've given us a detailed information. But as far as the question of certainty is concerned, it's not that they can tell us what are the basis on which fugitives cannot be surrendered. What they're saying that for all offences in the Czech Republic exceeding a certain threshold, then the fugitives could be surrendered. And they would tell us, which are the offences, according to the law, which would, attract a punishment above a certain threshold. And in our ordinance, we have a list of 46 offences. But as far as certainty is concerned, well, also there is an extra requirement that we have this double criminality requirement on our part. So even if it's a criminal offence in the Czech Republic attracting a certain level of punishment, then I think the offence would also need to attract similar punishment in Hong Kong. Mr. Leung. Chairman, if you don't mind my saying this, I don't think this is any different from what we were told last time. Last time we said that we wanted all the categories could be clearly listed. So it's not a question of clarity, but rather, like you said, it's a question of expression. All along, we've been talking about expression. What we're worried about is that we're not given the specific details. So even for this present exercise, and you say in future you will exchange the information with them, I think the outcome will be the same. It's not different from before, because they will not give you a list of the offences. And if there is discrepancy, there would not be exchange. I understand that. So there would need to be parity. That is, that we understand that there is only that the surrender of the fugitive is only possible when the offence is clearly defined. So I think your explanation just now is the same as the one you gave us the last time. As for the future, I still think that if there are some countries which adopt a similar approach as the Czech Republic, you really, do anything about it unless you refuse to sign the agreement. It's not that we don't want to exchange the information, but it's the other party which doesn't. So we're talking about the mode of expression, that's all, which is different. But I don't think there's anything new according to what you've told us this morning. A simple response, Chairman. I understand Mr. Leung's concern, but indeed, as we've said in this letter, other than the Czech Republic, there is this trend internationally that gradually more and more countries, more and more international agreements signed among countries, they also adopt an approach which doesn't use a list. Of course, the ultimate objective is that we can build up a broad network of bilateral agreements so that we can tackle crime, at the international front. So we would like to sign more of such agreements. So under the circumstances, we need to monitor the international development. With the change in trend, we have to ask whether we can accept that. We've studied our laws in detail. The new trend and our new arrangement is not in violation of our laws. And that is why we have that's why we've consulted the security panel of this council once, so that in our future negotiations we will adopt this approach, a model. So put it the other way round. You talk about the new trend. So does it mean that in future we will also need to change our model in order to cater to the approach adopted in other countries? Well, since 2005, some of the negotiations, we're stuck in some of the negotiations. Having consulted the security panel, we've already started to accept this model in the course of our negotiation with other contracting parties. Of course, there are other countries which would sign agreements with us based on the old model, that is using the list model. But more and more agreements are signed using the new framework. So does it mean that in future it would eventually also mean that we would also stop using the list approach? I think what Mr. Leung is saying is that now that we've signed this agreement, according to Section 3, bracket 2, each contracting party should submit a list of all the relevant offences to the other party. So you should talk about list this time when you negotiate with the Czech Republic. So next time, would it be that we would no longer mention the word list? We simply provide the relevant offences to the other party. Something like that. Because you're not mentioning the list anymore. So what will be so anyway, what you exchange could be a list or not a list. But this time you've put down that the list is required. And the counterparty has signed the agreement. So So I think the only thing we can do is to see what they will give you in exchange. Mr. Leung is asking, I think whether you could simply say, the offences pursuant of which surrender of fugitives are allowed. I understand. Like the chairman said, the Czech Republic agrees with this mode of drafting. We haven't even received the draft from the Czech Republic. We don't know whether or not eventually will give us a list. But as we learned in our earlier discussion, whether or not in future agreements there will be a different approach, or we certainly note down this comment so that in our future negotiation, in other words, if some countries insist that we should use the list, and we should do that, but if the contracting party doesn't accept a list approach, and we will simply give a description of the offences which warrant the surrender of fugitives. See it. In our previous discussion, I understood that in the course of such bilateral negotiations, we will be able to effect the surrender of fugitives. The question is that the counterparty and other countries as well, which use the continental law system, may not have an arrangement similar to those under the common law. If they're not able to give us a list, I think that and they have their own standard. I think we should. I think what Mr. Leung was saying is that we should ensure that certain offences committed in Hong Kong, which if we surrender the fugitives, will it be in violation of our values or our legal provisions? That is the most important. Whereas there,
唔係以我哋嗰個咧係嗰個價值嘅理念嚟講係強於佢哋嘅，咁樣嘅情況係保障翻。
So I think our values are stronger than us. So there is a guarantee here. I think we need to. I think it's important that the focus should be on this. Last time we said that, but the people in Hong Kong know which are the 46 offences, and this time we are also saying that we only surrender the fugitives if it's in relation to these 46 offences. So that's the crucial point. I don't necessarily agree that we only sign the agreement if they could, adopt the same approach as we do in surrender fugitives. Otherwise, I don't think there could be any surrender of fugitives at all, because the legal system is different from ours. I've heard that the administration has relied on this method. And the chairman also mentioned the point about the commencement order. I hope that when you work on the commencement order, you should also attach the list that is applied to us from the contracting party, so that we would know what to do. As you said, the exchange has been effected already. And that they are able to give us the required information.
係，我完全同意議員所講咧，就係
I fully agree with Mr. Yip. Whether it's the list or whether, using a list or otherwise, is simply a way of expressing describing the offences. The most important thing we are talking about are the safeguards, and under what circumstances can we refuse a request for the surrender of fugitives, and which are the offences under which we can surrender fugitives, and all these will not be affected. And we've adopted a new alternative approach this time, but it's not in breach of the requirements of the law. I also like to put on record that this is 100% safe. Now that you've signed the agree order with the Czech Republic, Article 3, subsection 2, you're saying that both parties will exchange the list. We don't know what the Czech Republic will give us, but suppose what they give us is not a list in the end. And then for the next step is we'll come to the commencement notice, and we may need to form a working group to look at it. Assuming that the future working group also agrees, and then it goes into effect. And then you have the first case of a Czech citizen committing an offence there and absconded to Hong Kong, and we want to extradite him back to the Czech Republic, and then he will seek for a JR in Hong Kong. And saying that according to Section 3(2), it is stipulated that there needs to be an exchange of lists, and if the Czech Republic doesn't provide such a list, then it would not satisfy the requirements of the agreement and the law. And therefore, it would not be possible for, since there is no list, there is therefore no offence which will serve as a basis for him to be surrendered. I'm not saying that you'll definitely lose in court, but definitely this is something that is debatable. And that problem cannot be resolved now, because you've now signed the agreement and the word list is there. So either you're saying that even if they do it by way of a description instead of a list, in the end, the judge will agree or decide that the description is the same as a list. But if they win, it would mean that we would need to sign the agreement again with the Czech Republic. And in that agreement, you need to provide to the others a list or a description of the offences so that you won't be challenged. As to how this subcommittee should proceed, I think there are two possible approaches. Either we will first you put it in the commencement notice, and when you submit the papers, then you have to give us the details at that stage. And the other option is more drastic for the government. And that is, it's like in the future. This time you withdraw this first, and you would wait for the exchange before you table what has been exchanged between yourselves and the Czech Republic before we will scrutinize the order. I'm talking about the orders to be forthcoming. Why don't we also adopt the same approach for this order? Well, in which case you have to withdraw this order. I don't know whether or not, this could be perhaps be embarrassing for the administration if you have to withdraw the order. But I think both options are acceptable. If you ask me, I would choose the latter. But I don't know whether I ask the government this question. Are you prepared to withdraw this order and wait until the exchange of the information has been effected before you will, table this to us again?
So, yeah. Well, I understand Chairman's viewpoint. As I said just now, we haven't exchanged the list with the Czech Republic as for what information they are going to submit, and will problems, as mentioned by Chairman, arise. I think at this stage it's difficult for us to give a concrete answer. We follow the established practices and the laws in preparing and submitting the order, and on this new drafting approach, members of the Council were consulted in the past, so I would suggest that members continue to scrutinize the order. Now, if you insist that the existing practice be adhered to, well, I will go on, but I will abstain from voting. Now, on the 2005 paper, in para 8 of the paper, it only mentioned that Hong Kong would provide a list. There was no mentioning of the other party not submitting a list. On the first 4 paragraphs, you set out the difficulties. And then in para 8, you said that for Hong Kong's part, the list of categories of offence in Schedule 1 to the ordinance will be provided to the other party. However, you didn't mention what the other party will give us. So in 2005, things weren't set out so clearly. Anyway, since you mentioned 2005, I'd like to say that you haven't mentioned what the other party will submit. You can say that it's implied in the previous paragraphs, but you shouldn't do things this way. And also, after the agreement has been signed, it still states that a list will be provided to the other party. So in fact, you're not suggesting that we should know that the other party would not be submitting a list. So that's my comment on the discussion in 2005, Mr. Leung Yum-chung. Just now, Mr. Yao mentioned that now we cannot determine whether the contracting party in the future would be able to submit the list. That's what you said just now. Yes, because it's yet to be submitted. So I think from what you said today and at the last meeting, it's extremely difficult. That's the view of their parliament. They only have a broad concept instead of categorized offenses. That's your comment expressed last time. So even if we follow the practice, we approve this order first before we further scrutinize the commencement notice at the next stage. Now, what if something goes wrong? Can we ask it not to take effect? I just want to say that, first of all, this is extremely difficult. Secondly, in other jurisdictions, as said by Mr. Yip Kwok Him, for jurisdictions adopting the continental law system, this is their approach, and if our requirement is to be satisfied, it will be very difficult. So my question is about what you're going to do in the future. It's very important. Even if we take a more relaxed approach, in the future, we may have to continue to take a relaxed approach. So yeah, I won't say that it's a relaxed approach. I want to reiterate a point. When the Czech Republic or other jurisdictions express that they cannot provide the list, I think it's not the case that they have only a broad concept. In these jurisdictions, their statute code is very long. It's unlike what we have in common law jurisdictions, and unlike what we have in the Fugitive Offenders Ordinance, in which we have a list. They don't have a list. All offences are included for surrender of fugitive offenders. However, we have safeguards, and that's why we agree to that description of offences. I don't think we are making concessions or that our system will be compromised. Our system, the spirit and the safeguards are here. I emphasize that they have a different way of describing the offences. It's not the case that they are not clear, and their way of description of offences is different from ours. And in our negotiations, that's the views expressed by many of the contracting parties. And that is why we need to make adjustments by adopting this new approach. And this new approach doesn't hamper the framework on the surrender of fugitive offenders. All right. I think that since the agreement has been signed and in the article the word list is mentioned, but we still can have a second bite. That is what we can still set up a subcommittee on the commencement notice. So the question is whether we endorse it so that they can have the exchange, and if there is something wrong with the exchange, we can stop its commencement. Although I think that the more drastic way would be to withdraw the order now and submit the proposal to our subcommittee again later after it has been exchanged. A point of information. How much time would it take to get meet our requests? Request meaning, on the Czech Republic's order. Request meaning, when will we be given the information? That's the case may be different for different contracting parties. It depends. 2 or 3 months, 2 or 3 years, or what? Please give us a time frame, at least. If it's 2 or 3 months or 4 or 5 months, yes, we will understand why. Sometimes maybe there's a changeover of government. So let us know whether it's 2 or 3 months or 2 or 3 years or what. Now, I ask this question because, of course, you can't answer on behalf of their parliaments how long it will take or the progress of work. I understand that. However, Chairman just now mentioned 2 possible scenarios. And I think ultimately we might just be dragging on our feet. And I think it's very difficult to stop its commencement. Let's say if we defer matters for some time for you to do the work properly, would it be better? We're not deliberately stopping you. We're just asking for further information. You can ask the other party for it. I want to ask this question as well. What if we don't endorse it at this stage? Does it mean that no exchange will be made? Does it mean that procedurally no exchange can be made? Perhaps you should be more sensitive in terms of the words you use, Chairman. Let's not use the word withdraw, but rather put it on hold. Okay, I understand that. Maybe this subcommittee can go into dormant stage. But that's not possible because it's by way of negative vetting. If the deadline is reached, then it will come into effect. So you should shut it down proactively before it comes back again. Perhaps let's hear from Mr. Sin as well. My feeling is that we should allow it to go ahead first. They don't have a list, but we do have a list of 46 offences. That's our bottom line, and that's our scope. That's our established practice. They might have a broader set. We might have a narrower set. I still think that at least we have controlled risks. I think it's acceptable that we let it go ahead. Mr. Yip? Yes, clearly, I think that they should proceed with it. I think we can take your suggestion at the time when the commencement notice is submitted. We can set up a subcommittee. I think that it's better for us to shut it down now and wait. However, I don't object if members think that we should proceed with this. I just want to make my viewpoint clear. Any strong views from you, Mr. Leung? If not, I have to say that since the other party has agreed to submit a list, we will let you go ahead. We're not going to ask you to withdraw the order. However, at the next stage, when you submit the commencement notice, please also give us this information in the electrical brief. Legal advisor and Mem Clerk, please put it down. And by then members can consider whether we should set up a subcommittee to scrutinize it. So much for this part on Czech Republic's order. Oh, no. Second part, in relation to good faith. In the paper, I'm looking at the English version at the bottom of page 3. You said that it's rarely used nowadays. Internationally is now rarely used, and you also mentioned that in some other agreements it's not used either, and not even in the UN model text, right? But in the past, where was it used? The model text came by in the 90s. And that was the international model text, right? Otherwise, we won't be following it. We didn't add this bit ourselves. Legal advisor, am I right? That's the international model text used in the past. In the 1990s, during the Sino-British Joint Declaration, liaison group in relation to the negotiations on the surrender of fugitives, that was the model text prepared. I can't answer for now whether we drew reference from the international model text. It's been some time. I just want to say that now it is rarely used internationally. That's a point of history. If you can, please give us more information later. So at least in relation to the negotiation matters before the handover, both the Chinese and the British government agree that this should be a safeguard. So let's look at Para 3 or page 3. The person shall not be surrendered if the request is made for the purpose of prosecution and punishment on account of race, religion, nationality, sex, or political opinions, or might be prejudiced at that person's trial on account of the above reasons. And
request not made in the interest of justice. OK， 咁我就留意到呢個 many 呢個字，即係換句話講咧，你都覺得咧係。
That means you don't think this it includes all. This is not exhaustive.
公義
Is it really for justice? I think, in fact, it could be broader than for the purposes of prosecution on account of race, religion, and so on. I think you're being very careful here. You use the word many instead of dealing with all situations. So there would be scenarios in which we would have more. In other words, there would be a weakening in the protection of human rights. I must clarify whether this is the case. I'd like to know how many agreements we've signed in the past which contain the phrase "made in good faith." I think there are many. So what I want is this. You say whether or not each an agreement could be effected in good faith. But I don't think you should take it to mean that this subcommittee will not, that we do not insist that you will continue to fight for this protection when you negotiate with other parties. I think for the Czechoslovakia, at least this is a country that we can trust, and therefore, in the absence of that, it is still acceptable. But there could be some countries. Personally, I'm speaking. I don't represent the other members. I don't think that it would be a safe agreement. This is just what I'd like to remind you of. So, do members have any further thoughts or comments on this? I hope you will still fight for this, and if you cannot, then you come back and tell us, and that is all. That's the economic and political system of the country concerned, whether members can judge whether or not it's stable and reliable, whether or not it's safe for us to sign an agreement with that country. All right, if there are no further comments, we can wrap up our discussion on this. So what exactly is our timetable, Secretary? We need to submit a verbal report on the 13th, and the announcement is the 31st for the the 8th of January is the date on which members can speak in council. Right. Members, when I set the date for this meeting, this happened to clash with another meeting I need to attend. We originally scheduled to finish 10:30. I must apologize because for the other meeting there are not many people who will be attending, and they are starting at 9:30. So I'd like to consult with members whether you would like to continue with the positive vetting of the other two orders. That's the ones with the mutual legal assistance agreement with Spain and Czechoslovakia. If members wish to continue, could we elect an acting chairman to stand in on my behalf? But we also need to be mindful of whether or not we can form a quorum. We're at 9:45. There is an event downstairs, and I also wish to attend. That's actually the event celebrating the 170th anniversary of LegCo. No, it's actually the transition from actually the exhibition of the 170 years of history of LegCo. I think it's scheduled for 9:45. Would it take much longer to scrutinize the other two orders? It doesn't appear to be so controversial. I don't know. According to past experience, it's not. But I think it's safer for us to go through it clause by clause, and it'll probably take an hour. Well, in that case, why don't we schedule another date? Well, fortunately, for that one, it's positive vetting, so we don't have a tight schedule. Of course, we will still need to find a slot to do this as possible, and it's easy because we don't need a large quorum. I must apologize to the administration because I think the other one is a regular meeting held once every 2 months, and this has been planned in a rush. So I'm sorry. So, or at least we've finished the negative vetting of the fugitive order. So, to remind members, deadline for submission of CSA is the 31st of December, and we'll need to report to the House this week. 13. Next week, sorry, the 13th. We will report to the House Committee. With that, I think we can adjourn the meeting now. Thank you.